Hello, everyone, and welcome to Uncivil Law. For today's case, we are trying to decide what constitutes cyber stalking and what constitutes stalking. What kind of behavior is prohibited? This is a story of a father who tried to contact their child who had been granted a new guardian, and what contact was lawful or not. So this is the case of Santiago versus Leon in the District Court of Appeals for Florida, State Appeal Court in the 3rd District. So we're going to read this case and try to learn a little bit more about what constitutes stalking behavior and what constitutes lawful behavior. So let's get started with this. Santiago and the child's father had a long-distance relationship during which they were born through a surrogate. The relationship ended when they were 1.5 years old. So this is a gay couple. They were in a gay relationship, and the father, then they had a child through a surrogate, but then the relationship ended. And so now we're trying to determine custody relationships and so forth of a gay couple who had a child through a third party, which is also super fun in family law land. On July the 12th of 2017, the father, so the natural father, not to be confused with the partner who's not a father, filed a verified petition against Santiago, his former lover, in the lower court, seeking a permanent injunction against Santiago based on alleged stalking of the child. The verified petition began in February of 2017. Santiago apparently had stalked his own child, depending on whether or not it's his child or not, depending on all those fun issues about gay parentage and what makes a child and so forth and so on. So he's stalking this child by getting a tattoo of his name across his body. I'm not quite sure how that's stalking to get a tattoo. Posting images of him on social media and representing thereon that he was his son. So that the guy who's not the biological father says, "This is my child." Mailing packages to the child, twice emailing the father to express his love for the child, contacting the father's surrogate in search of information about the child, appearing once outside the father and the home, maybe with a boombox or something, and driving by the father's restaurant that they were patronizing and making eye contact with the father and the child. The father further represented that Santiago frequently went to the same restaurants at the same time as father, oftentimes when the child was present. So yeah, so we've got a gay couple with a child. Of course, only one of them is the natural father of this child, who had it through a surrogate, and the relationship broke off. And now the one that was the donor to this equation is trying to exclude the one that was not the donor to this equation. And there is the latent issue here of who are the natural parents of this child when you have a gay relationship, which is just a fun issue that's sort of lurking in the background that we're going to pretend to ignore for the moment and just deal with whether or not this was stalking, leaving aside that explosive issue for another day. The law of Florida creates a cause of action for an injunction to protect against stalking because, of course it does. You can go to court and say, "Please stop stalking me," and the court will say, "Stop stalking." The statute authorizes a trial court to enter the injunction to say, "Stop doing this," against a respondent whose conduct meets the definition of stalking. So stalking does have a legal definition. Stalking actually means certain things. So when you say someone is stalking something else, you have to actually look, and what does the law actually say stalking is? Well, we can say what it is in Florida. So here's the definition in Florida. The Florida definition defines stalking as when a person willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person. Not necessarily the greatest definition I've ever seen in my life, but it is a definition nonetheless. To have an issuance of stalking, the record must establish that the respondent either followed, harassed, or cyberstalked another. So it has to be one of those things, and it has to also be done willfully, maliciously, and repeatedly. All right, so let's figure out if that happened. In this case, the biological father established at most that the non-biological father had appeared outside the biological father and his child's home on one occasion, and that the non-biological father, who travels in the same social circles as the biological father, patronizes the same restaurants as the biological father and the child. Indeed, at no point during the non-biological father's testimony was the non-biological father ever asked to explain any of these occurrences. So there was testimony. No one ever asked him, "Why were you doing these things?" No one asked him, what was going on. They just said, "Did this occur? Did this occur? Did this occur?" No one ever bothered to ask why. Okay. The non-biological father's conduct, without more, is not an example of following for the purposes of this law. So the things that he did does not comprise following. The law defines harassment as engaging in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. So to harass, you have to direct it at a particular person, and it has to actually cause that person substantial emotional distress. That's what harassment means. To this end, much of the non-biological father's conduct, sending 2 emails to the biological father, contacting the biological father's surrogate, and regularly patronizing the same restaurants where the biological father, but not the child, was not directed at the child. So maybe you were harassing the biological father, maybe, but you can't be harassing someone who isn't there because it's not being directed at them. In fact, as discussed below, it is undisputed that the child was unaware of any of the non-biological father's conduct. So the child was not aware that any of this is happening. So it's a little bit difficult for them to have an extreme emotional reaction to something they don't know is happening. Therefore, it's insufficient to constitute harassment as a matter of this definition. Moreover, because we're told the father unequivocally at the hero below that the child was unaware of the non-biological father's conduct, there was no evidence that it constituted substantial emotional distress because, you can't be having substantial emotional distress of something that you don't know is happening. Even if the child had been aware of the conduct, however, none of the conduct, for example, getting a tattoo, which, how is that harassing? Twice emailing the father, not directed at the child, mailing several packages to ML, which is directed at, but did it cause harm when they don't know about it? Contacting the father's surrogate, not directed at the child. Appearing once outside the home, questionable whether or not that's directed at the child or not. Frequenting the same restaurants as ML, which again, questionable. Making eye contact with ML from his car. I don't know about the eye contact. Is that, yeah. And social media posts without more amounts to harassing. Even if the non-biological father's conduct could satisfy the definition of harass and was willful, it does not support the definition that it was with malice, which is also in the statute. So even if it was willfully done, which, questionable at best, was it being done maliciously? Was it being done essentially, for lack of better words, with a purpose to create harm? And no, not really, no. The law defines cyberstalk as engaging in a course of conduct to communicate or cause to be communicated, words, images, or languages by or through the use of electronic mail or electronic communication directed at a specific person, causing substantial distress to that person and causing no legitimate purpose. While numerous postings of comments and pictures to his online accounts may have been referencing the child either overtly or indirectly, this conduct of merely making posts on social media is insufficient to constitute cyber stalking. Rather, the law has mandated that the threats be directed to the individual, not by its content, but by its delivery. You have to be intending it to go to that person. Merely discussing them is not directing it. You have to try to deliver it to that person. Because social media posts are generally delivered to the world at large, the courts have interpreted a course of conduct directed at a specific purpose to exempt social media messages in general. So it is not said here by this court, but it does seem implied that if you are making a social media post that is tagging a specific person, so if they have a social media account and you tag them, or if you're responding to their social media account, so they would see it. So if you are, or you're sending a DM or something like that. So if you are doing something that would specifically direct it and bring it to their particular attention, then maybe you have a problem. So that does seem to be implied in this language, but that isn't here, right? It was merely a post about the person. And also the child probably doesn't have a social media account in any event because they're relatively young. And so how can it be directed at them? Doesn't really work in this particular context. May work in some other context, but not here. The 4th District in Florida has held where comments are made on electronic medium to be read by others in general, They cannot be said to be directed at a specific person. Again, I'm adding the word in general to this, but that does seem to be the implication of it, right? There's a difference between just making social media posts at large and that are actually in some way directed at, being targeted, trying to deliver it, bring it to their specific attention. There's a difference there. There is no evidence introduced at these 2 evidentiary hearings conducted below that the non-biological father had in any manner tried to or did deliver his social media posts to the child. On the contrary, the father testified that he went to the non-biological father's social media sites to read the post. So his father said he went to go look for it, which means it wasn't being delivered to him. It didn't pop up in his feed. And also, he's not the target in any event. So yeah, even if the non-biological father had sufficiently directed his media posts at ML, there was no evidence that they caused any distress to ML because, again, he was completely unaware of it. We recognize that the non-biological father's conduct might have been, as the trial court put it, creepy, which, okay, I don't know whether or not that's creepy. Is it really creepy to get the name of your son tattooed on you? Is that creepy? I don't know. Some of the stuff, but whatever. The trial court thought it was creepy at least. But for us to actually, issue an order, it actually has to be illegal. Creepy is not illegal. So that brings us to the end of our discussion of Santiago versus Leon, a case with a gay couple where one person donated their essence to a surrogate and they had a child and they split apart, and now all kinds of wonderful trauma and all kinds of stuff is ensuing as a result of this. And so the question for our immediate purpose is the non-biological father harassing the child? And the answer to that is no. No. The child is completely unaware of it, so you can't get to severe emotional distress. It's not malicious, and no. So while there might be some things that you can do, at least into this case, not so much here. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.